All right. Thank you for joining us. I know that we still have others that will be joining us here, but we are going to go ahead and get started because we have a jam-packed agenda for you today. Thank you for joining us. My name is Terry Kimball. I'm the President and CEO here at the Chandler Chamber, and I have two fantastic experts in the field that are joining me here today. I have Andrea Marconi, who is with Fennemore Craig Attorneys, and I just want to read a little bit of background about Andrea. She is an experienced litigator in business litigation and legal services group. Her broad spectrum of work encompasses many areas, including the complex commercial litigation, franchise litigation, and banking issues, such as payment processing, credit card processing, and ACH transactions. And I will tell you, anybody, that's very relevant in today's society because everybody is going to that. So in addition, Andrea has experience with entities throughout the healthcare industry, including representing health insurers and medical billing companies in numerous matters, such as coverage issues, regulatory compliance matters, and defense of bad faith claims. Routinely arbitrating and contesting cases in the state and federal courts around the country. She has extensive experience litigating a wide array of real estate, contract disputes, insurance coverage, indemnity matters, restrictive covenants, and trade secret litigations. Holy cow, Andrea, we got the whole ball of wax with you. I love it. So I'm going to let you take it from here, and then we will also be hearing from Paula Whittakin with the SBDC here, and she's going to answer your questions on changes on PPP and payroll protection, and on the payroll protection and EIDL and all those kinds of things. So Andrea, we're going to let you kick it off and take it away.
Wonderful. Thank you so much, Terry. Hi, everyone. I am thrilled to be here today with the Chandler Chamber and all of you. And I'm going to go ahead and share my screen, and then we'll get started with our presentation. Here we go. I think I've shared my screen, so let's hope that it works for everybody. I'm going to go ahead and, there we go, move myself to the corner here. Well, hi, welcome to today's webinar sponsored by the Chandler Chamber of Commerce, and we are going to discuss best practices for mitigating risk as businesses move forward in this COVID-19 world we find ourselves in. And part of our discussion will also include tips and tricks for preparing COVID liability waivers that have the best chance of being enforced. Today's event is part of a series of resource and recovery webinars sponsored by the Chamber, and I'd encourage business owners to attend as many of the webinars in this series as you can. I've attended a number of them myself, and I think they're just fantastic learning opportunities, so I highly encourage them. Now, I know people want to return to life as normal as possible right now, and that is really great. But it is vital that the business community remembers that things have changed. And so how we do business needs to keep up with the constant changes that occur almost literally every day concerning COVID-19. The fact is the coronavirus is still with us and it's still spreading. But business can still be done in this environment, and you can still serve your customers and do what you do best. What is important is to make sure that businesses modify their procedures and their interactions with customers accordingly, and really take reasonable steps to keep people safe. That is the best way to mitigate the legal risk of harm against a claim from a customer who may try to argue and file a lawsuit later saying that he or she contracted COVID-19 because they interacted with your business. Now, I understand that there's been some prior webinars in this series that focused on employers and employees and their legal rights and obligations to each other. Now, today, I'm going to focus a little bit more on business interactions with your customers and the public. And certainly management of your employees is critical to that, and we'll discuss how that plays in. But I did want to say that my focus today will be more external and how businesses interact with the public and what you can do to take reasonable precautions. Now, Terry did a fantastic job of introducing me, so thank you for that. And I won't do too much more, but if you're wondering who I am, there I am on the screen. I am a director or partner at Fennemore Craig in our business litigation group. And as Terry mentioned, I do litigation and help businesses resolve legal disputes in a wide variety of areas. I also really enjoy helping businesses strengthen their contracts, their policies, and their procedures to try and avoid legal disputes from happening in the first place. My law firm, Fennemore Craig, we are a full service business law firm that was actually founded over 130 years ago, before Arizona was a state. And since that time, we have and continue to help businesses with their legal needs in virtually every area you could think of, from corporate transactions, intellectual property, litigation, healthcare, trusts and estates, you name it. We are proud to be a member of the Chandler Chamber of Commerce, and we're really excited about the growth and innovation in business that's occurring in Chandler and elsewhere, and we're happy to be a part of it. And I also just personally am a proud Chandler resident. I live in Chandler with my husband and 2 boys who are both students at CUSD schools. I really love this city, and I enjoy helping businesses and business owners who thrive in Chandler. Okay, we wouldn't have a webinar from a lawyer if we didn't have a disclaimer. So just really briefly, I know, right? So just really briefly, the regulations regarding COVID-19 are changing constantly, literally every day. So this webinar is meant to provide you the best overview of law and regulation that I have is active this morning, but it may change. And also this is just more of a summary and my discussion thoughts. So I don't intend it to be legal advice, but certainly feel free to contact me or any other attorney you're comfortable with after this presentation if you have particular questions. So briefly, let's talk a little bit about where we were and then where we are today. So as many of you probably already know, in early to mid-May, Arizona businesses began to reopen. On May 12th, 2020, Governor Ducey entered his executive order 2020-36, which was known as the Stay Healthy, Return Smarter, and Return Stronger. In that order, Arizona officially entered phase 1 of reopening. And that executive order was really important because it outlined a number of different requirements and guidelines that businesses reopening should be doing in order to try to keep people safe, and put those policies in place based on guidance from the CDC, the Arizona Department of Health, OSHA, and Department of Labor. We've already heard about many of these and are living with them every day, but they include things like promoting healthy hygiene, intensifying your sanitizing and cleaning practices, monitoring employees for sickness and symptoms of COVID, social distancing, providing necessary protective equipment, encouraging teleworking for your employees as much as possible, and limiting congregation of groups in your businesses to no more than 10 people where feasible. Well, where have we gone from there? As we all know, cases started spiking in Arizona, and some businesses have had to since close or be more limited. So as of June 29th, with the Executive Order 2020-43, Governor Ducey, generally speaking, prohibited public events of 50 people or more. There are some limited exceptions with city or county approval, and certain facilities have now been forced to close. So indoor gyms and fitness clubs, bars, indoor movie theaters, water parks, and outdoor pools are open, but they have some limitations. This order is currently in place until July 27th, although it can be considered for revision or repeal every 2 weeks thereafter. So that's definitely a stay tuned on that one. And then the most current executive order was effective on July 11th, and that has a limitation on indoor restaurant dining to less than 50% based on the permitted fire occupancy load. There's a number of other restrictions I won't go through in detail today. The biggest one is for restaurants to keep at least 6 feet between tables of different groups, unless there's glass or plexiglass, that kind of thing. Now, although some businesses are closed or have limits on operation, many more are open and interacting with the public and serving their customers. So the question I get from people literally almost every day, if not multiple times a day, is if a person visits my business and they later contract COVID-19, can that person sue my business? And gosh, I understand that concern. And unfortunately, the answer is yes. A person can try to hold your business liable for a COVID transmission claim. The biggest risks are businesses certainly that are client facing. So if you're in a service business, for example, that requires technicians to enter customers' homes, restaurants, retail, hospitality, etc., All of those probably have the biggest risks. But I do want to be here today to not be the lawyer who shares the doomsday scenario, because that's not productive for anyone. I don't want you to be unnecessarily scared from running your business and doing what you do best right now. What we're here to talk about today, and what I think we can all learn, are some of the most common bases of legal claims related to COVID transmission, and how you can best either avoid that claim, or if one happens, best defend your business quickly. So let's talk about the most common case for transmission liability is going to be a claim for what's called negligence. And a plaintiff bringing a claim for negligence has to generally prove 4 things. They have to prove that you as a business owed them a duty, that you breached that duty, whether as a business entity or possibly a business owner, that the breach was the cause of their damages, and that in fact they were actually damaged. Now, negligence is most likely going to be the types of claims that we see in the legal field related to COVID transmission. There are certainly other possible claims. They include things like fraudulent misrepresentation, which is basically either an actual affirmative misrepresentation made. So an example would be stating that all employees are free from COVID when you know as a business owner that one of your employees was diagnosed and is home quarantining. And a fraud or misrepresentation claim can also be based on omitting very important information. So the business knows, for example, about a diagnosis of an employee, but doesn't disclose it. There could also be claims for negligent misrepresentation, which is essentially a company didn't mean to make a false statement, but that company failed to exercise reasonable care when communicating information that later turns out to be false. And lastly, there could be wrongful death cases. That is if someone unfortunately passes away from COVID and tries to, make that type of a claim against a business. There's one current case in the Seattle area right now that folks are watching. It's a wrongful death case that's been brought based on a fraud theory, and it's related to someone's death in a nursing home. That plaintiff is accusing the nursing home of failing to disclose material facts about whether other residents in the home had the virus, so that they could try to keep the plaintiff's mother at the facility. So this case is in its early stages, but a lot of legal watchers are keeping an eye on it because it's one of the earliest COVID cases that's filed, and may give us an idea of how courts look at these things. But as we talk about negligence cases today, let's kind of go through the 4 elements a little bit and what you as a business need to try to do to have those elements not apply to you if someone contracts COVID after coming to your business. The first is the concept of duty. And duty here is really going to be about knowledge with respect to a business. Now, a court, so not a jury, a judge, is early on in the case going to have to decide whether your business owed a duty to the particular plaintiff. And it would be essentially a duty to not infect that person. Now, a court is only likely to find that your business owed a duty to a plaintiff who claims to have contracted COVID from your business if the business had knowledge of the presence of disease. And knowledge can be found in 2 ways. It can be actual knowledge, so you actually knew that one of your employees, or even perhaps a customer who came into your business, was diagnosed with COVID, or it could be constructive knowledge. And constructive knowledge is essentially the law saying that you had enough information that you should have known of the presence of disease in your business, or that it was highly probable that there was presence of disease, but didn't do anything about it. This is kind of trying to prevent the ostrich defense. So stopping a business from merely, sticking your head in the sand and just claiming woeful ignorance. And a court here is going to look at all of the facts to determine whether such knowledge exists. Now, you can minimize the chances of owing a duty to a plaintiff, and you can do this in a few ways up on the screen here. First and foremost, take all reasonable steps that you can to avoid actual or constructive knowledge of risk of infection. So what does that mean in English? That probably means, for example, if you think an employee may have the virus, if an employee, for example, reported symptoms or reported obviously a diagnosis, or even that they took a test and are awaiting a diagnosis, the employee should not be around customers and should not be around other employees. That employee should stay home, follow the CDC quarantine guidelines and testing. It's really important not to remain deliberately ignorant here. If the facts show that you should have known of a risk or infection in your business, you could have liability. So you want to make sure that you're learning the facts and then taking appropriate action. Other things you can do with employees to show that you're not being ignorant to their health is requiring employee temperature checks before they come into work. Some businesses are doing this where you ask the employee to do a temperature check at home, and then they have to certify before coming into work that day that they have in fact taken that temperature check, that the temperature is below a certain identified level. And you can also, at that same certification, ask your employees to certify that they have no other symptoms of COVID-19, you list those out, or also that they haven't been around anyone that either has been diagnosed or that is showing symptoms. Another way you can do that is actually ask employees to take their temperature right when they come to work. A lot of people are doing that now with those infrared thermometers because you don't actually have to touch someone. You can just kind of hold it in front of their forehead. You just want to make sure you're having employees do that in kind of a private, confidential area, and that you're consistently applying the rules so that everyone's doing it. Also, you want to make sure that you're following all of the applicable local, state, national, and if your business has any industry-specific guidelines. Restaurants are a great example here. There are some really great restaurant protection guidelines out there. So you want to make sure that you understand those and are following all of them, because that is going to go a long way to show that you have been doing everything you can to not be ignorant about the health of your employees at the office. Also, of course, requiring masks or PPE, if that's applicable to your business, would make a lot of good sense. The end result of this could be that a court finds that you had a lack of knowledge, that there was presence of disease in your business or facility, and then a court can find early on in a case that you didn't owe a duty, and then case over, case dismissed. So you can win early and not have to spend all the time and money to go through a full-scale litigation, which would be fantastic. I do want to encourage here that this isn't a one-size-fits-all thing. I wish I could just give you like a bullet point list of 10 things that every single business should do. But it doesn't work that way in negligence because the cases are really fact-specific. So what I would encourage you to do, and to contact an attorney for assistance if you need it, is to look at your particular business. In particular, think about how you interact with the public and other customers, and what is your level of interaction, and take precautions accordingly. As a general rule of thumb, the more you interact with the public, the more safety precautions you really want to be putting in place with your employees and your customers. So let's talk about the next element of negligence, which is breach. So if you are found to have owed a duty to the plaintiff, then the court has to ask the next question, which is, did you or your business act reasonably under the circumstances to avoid harming others with the spread of coronavirus? Now, in most cases, this is another fact-intensive question. So it is subject for a jury to look at, which tends to mean you go a little farther in your litigation case, almost to the end of the road. One thing I want to say, though, is reasonable doesn't mean perfect. You are not held to a standard of perfection. What you're held to a standard to is what a reasonable average person would do under the circumstances. Now, one thing to note is that the standard of care does evolve over time, and particularly with COVID, courts are likely going to say that the standard of care, what's reasonable, evolves over time as we learn different things about this pandemic and how it spreads. So a great example is early on in the pandemic, I think there was less information out there about the benefits of wearing masks. And so if a business owner wasn't requiring everyone to wear masks, it's more likely that that's not going to be a problem and that the person still would be found to be acting reasonably, even if the business wasn't requiring all employees or customers to wear masks, because what was reasonable was just a different standard. Now, Fast forward a few months even, with all the additional information we have on the importance of masks, let alone mandates from the county and Maricopa County and many cities, a business that doesn't consistently enforce a mask policy, whether for employees where it's applicable or customers, will likely be found to not be acting reasonably and thus below the standard of care. So it's going to change over time. Now, while most businesses will be held to kind of the reasonable average standard I just mentioned, there are certain types of businesses that may be held to a little higher standard and a more professional standard of care, where the business would be judged on what others in their industry are doing. An example here is things like medical providers, and that's doctors and hospitals, but that can also be, blood testing, your imaging places, that kind of thing. Those are in the healthcare industry, and that's going to be held to a little higher professional standard. So the question will be, what were others in your industry doing, and were you doing something reasonable the same as they were to protect customers? So even if a customer proves that you owed them a duty and that you breached that duty, then the customer has to prove that that breach of duty is what caused them to contract COVID-19. I think this is going to be very difficult for plaintiffs to prove. Not impossible, but difficult. And this is where a lot of the fights are going to be. So the plaintiff has to prove they were infected at your business and not anywhere else. Now, this will be fact intensive, but depending on the plaintiff, it's going to be real tough for them. Let's take an example. If someone is kind of out and about in the world, say they're going to their office for work, either on a daily basis or even a couple times a week, they're spending time with folks outside their family, they're going to restaurants, they're going to the grocery store, etc. And then they come down with COVID, but they want to say that when they walked into your particular business, that's what did it. That's going to be a tough road to hoe for a plaintiff. But if you have a plaintiff who's really been quarantining at home, not going out much at all, but they happen to go to your business and for some reason and nowhere else, they may have a little easier time to show that causation. That's particularly true if your business, shortly before their visit, either had an employee who was diagnosed with COVID or another customer. So when you look at all those circumstances together, there could be causation, but it's going to be kind of tough. So here's the question too, what about employees? Can an employee sue you if they contract COVID-19 while at work? And the answer is, in Arizona, employees generally can't sue their employers for negligence. The sole remedy is through the workers' compensation program and the workers' comp insurance. But even then, just to let everyone know, if an employee is making a workers' compensation claim, the employee still has to prove legal causation. So they still have to show that they contracted COVID-19 while on the job, which again, depending on their particular circumstances, may or may not be difficult to prove. So we've talked about some of these negligence claims and the elements. So then the question is, are these lawsuits going to be successful? And what do I do to protect my business? And what I'll tell you to the answer of will these lawsuits be successful is, well, it depends. It depends on the facts and circumstances, as we've talked about. I do think plaintiffs are going to try to file some of these cases and see what happens. But I do think most plaintiffs are going to have a pretty high bar to prevail in a negligence suit, because among other things, it will be pretty difficult to prove that they contracted COVID-19 simply by going to one business versus another. That said, even if a plaintiff isn't successful, they can still sue your business, and your business will have to spend time and money defending yourself, and that takes you away from doing what you do best. So let's talk a little bit more about how we either can avoid these lawsuits, or if the suits happen, be in a better position to prove that you didn't do anything wrong. That word reasonable pops up again, and it's really all about taking reasonable precautions depending on the type of business you have to protect customers. The most important thing that you can do right now is to show that you have followed all of the applicable guidelines that are out there today. And I know there's a lot of them, and I know that they're changing on a very rapid basis, so it's tough to keep up. but to do your best to keep up with the state guidelines, any local guidelines in the cities in which you operate. The CDC has a number of guidelines on their website, as well as OSHA, the Occupational Safety and Health Administration. That's a national organization. The Arizona Department of Health also has a number of guidelines on their websites. Especially also consider if there's any industry specific guidelines. You want to make sure that you know them and you're following them to the best of your ability. These are the things that we hear about every day. Social distancing, requiring employees and customers to wear masks or gloves to the extent that applies to your business when interacting with customers. Enhanced sanitation and disinfection is very key, and really trying to only come into direct contact with customers where it's absolutely necessary for your business. And unfortunately, there's no one size fits all. You may be thinking, well, shoot, what if I don't have my customers wear face masks because my business is outdoors? And so that's technically not required and it's 110 and nobody wants to wear them. Or you may be thinking, what if I technically am following all the masking requirements? I'm doing all the right things in policy terms, but I know my employees sometimes don't consistently enforce. Shoot, do either one of these reasons or others mean I'm automatically negligent? And the answer is not necessarily, but maybe. And really think about it holistically. If you maybe aren't doing one thing that, folks might say you need to be doing, that doesn't necessarily mean you're negligent, but you want to look at your business holistically and say, at the end of the day, everything that we've got going on, are we taking as many steps as are reasonable that we can to protect folks? A great example is, for example, if you don't have customers wear face masks because of the nature of your business, say your work is done outside and the masking requirements may not technically apply because you're also enforcing social distancing and you're doing enhanced sanitation procedures, then you have an argument and you've got evidence that you're not acting unreasonably for your type of business. But what I want to say to you is consistency is key here. What you want to make sure is that you put policies and procedures in place for your business for safety, masking if it applies, social distancing, cleaning, etc. And that those policies and procedures are known by your employees, that they're trained on them, they understand them, and that they're consistently enforced. So for example, if one of your policies is having employees report no symptoms or temperature checks before they come into work, you need to make sure that somebody is keeping an eye on that and watching it and consistently enforcing it. The policy that you have is only as good as the enforcement, so you just want to make sure that's happening. I would also really recommend documenting your efforts to protect customers. You can do this in a couple different ways depending on your business. You certainly can document what you're doing internally. So you can have a checklist or have written policies and procedures in a little binder, make it your COVID policy binder, and keep that. So if later someone asks a question, well, what was your business doing to protect customers? You've got it right there, either ready to show customers, or if heaven forbid a litigation comes up, to be able to show, here's all the things we did. And we've had that in place the entire time. If your business is really public facing, you may think about showing that checklist or something similar to your customers. For example, I'm out and about at restaurants from time to time, and I see a number of restaurants have put little one piece of paper next to their either front door or some of the tables that say, here's the things that we're doing to protect you. And they kind of list out a bunch of bullet points. Depending on your business, that may be something really great to do, because it not only makes your customers feel good, but from a legal perspective, it does help to show them all the things you're doing. And it kind of puts them on notice that you're going above and beyond and doing what you need to do to protect them. So that if later a customer comes down with COVID, they may not look to your business first as, who do I point the finger at? Because they would think, well, gosh, that person was very honest with me and telling me upfront all the things that they were doing to protect me. Warnings are also something that you can consider. And there's two types of warnings you can look at. One is warning customers of COVID transmission and the contagious nature of COVID when they enter your business. I have seen this on some businesses Not a ton, because I think folks kind of think it's obvious that we all should know COVID is out there and it's contagious. But if you do, especially have a lot of customers coming into your business, you may want to consider a warning at the front door that lets folks, just reminds them, you know, you are out in the world and this is contagious. People are asymptomatic and we're doing all the things we can, but, you know, please be warned that nothing is 100% effective. You also should warn customers and employees immediately if you have reason to believe that they have come into contact with either another employee or a customer who you later learned has been diagnosed with COVID. And this is a little tricky sometimes, especially with employees. You need to make sure that warnings are anonymous and that you're keeping the confidentiality of any diagnosis very secure. You never want to say the name of who has been diagnosed, or even any identifying information that might get people thinking who has been diagnosed, because that can violate HIPAA and potentially Americans with Disabilities Act requirements. So if you have one of these circumstances where either an employee is diagnosed or a customer and you want to know more about a warning, I would say definitely consult an attorney on that, but keep it in mind that warning customers is really a smart idea. So let's talk about waivers. Waivers is a really hot topic right now, and this is what I want to end my presentation with. In Arizona, you can waive liability and release a business from liability before an injury has occurred. I'm sure I've signed, probably hundreds of waivers in my life. I'm sure most of the folks on this webinar have done that as well. Waivers of liability are enforceable in the state of Arizona, and they are valid when they're done correctly. How courts look at them in Arizona is basically by saying it's a defense against a negligence claim, saying and arguing that the person assumed the risk here of COVID infection or whatever other harm is covered by the waiver. You can have a waiver of liability that's express, which is a contract signed by the customer. You can also have an implied waiver of liability that can be implied under the law when certain circumstances show that a plaintiff was aware of the risk of transmission but voluntarily continued the activity anyway. I would suggest, if having a waiver of liability related to COVID is important to you for your business, have an express waiver and don't rely on any implied waiver, because no one really knows what the courts are going to do with that right now, and it's just not very effective for you. Okay, in Arizona, courts and juries are going to look at two factors when deciding whether to enforce a liability waiver. The first question will be, does that waiver and release of liability comport with public policy? And did the parties clearly bargain for the release or limitation of liability? If those two questions are answered in the business's favor, then you have a much stronger chance of the liability waiver being enforced. So let's talk about public policy. Here, a business needs to establish that the waiver doesn't violate public policy. And things that juries and courts are going to look at is, first of all, making sure that there's no employment relationship between the person who signed the waiver and the person who is requiring the waiver. To be clear, in Arizona, you cannot make a waiver of liability for COVID or anything else a condition of employment. So definitely don't want to have your employees signing these liability waivers. Focus on customers only. And the courts are going to want to look at, was there unequal bargaining power? So a person, generally speaking, shouldn't be compelled or can't be compelled to participate in an activity if they don't want to sign the waiver. A waiver is much more likely to be enforced when the person can choose if they want to sign it or not and walk away if they don't want to sign. Now, as a business owner, you, generally speaking, can refuse to provide services or allow that person to participate in the activities of your business if they refuse to sign a waiver. Where this may be a bit of an exception is in essential businesses. Things like grocery stores, even banks, healthcare providers, law firms like mine have been deemed essential businesses. Courts are less likely to enforce a take it or leave it waiver, including a COVID waiver for an essential business, because a customer is more likely going to feel like they're forced to sign it and that they can't walk away. So if you're in an essential business, I'm not necessarily saying you absolutely can't do a COVID waiver, but you're really going to want to think carefully about it and make sure it's very carefully crafted and contact an attorney to walk through that, because it is less likely to be enforced in a truly essential business. And then lastly, some of the questions will be about public service duties that are owed, or is a person a member of a protected class from the business? Here, what I would say is think about things like police, fire, even hospitals. You know, if your home is on fire and the fire department comes to put out your fire, no court in their right mind is going to enforce a COVID liability waiver that the fireman hands you before he will put out the fire in your house. So those kinds of things are going to make it very unlikely for waivers to be enforced. One thing to keep in mind is you can only waive liability for general ordinary negligence. So Arizona courts will not allow a waiver of liability with respect to COVID or otherwise for the business's gross negligence, recklessness, or any kind of intentional misconduct. And one thing to think about if you're a business with an existing contract with your members or customers, say you're a gym or maybe any other business with a monthly membership, is look at the terms of your existing contract with your customer. And you may even have an existing waiver. I would say make sure your contract permits amendment before you try to amend and add a COVID liability waiver. Does your customer have to agree to the amendment, or can you unilaterally amend your contract? And be prepared that if you have a long-term contract with somebody, they may prefer to terminate the contract rather than sign the COVID waiver. So you kind of have to make that decision of what's more important to you. And if the customer terminates the contract with you, then your contract terms will dictate what happens next. So for example, do they get a prorated refund of any dues paid or any membership fees paid? So the second thing the courts will look at for liability waiver is, did the signing party bargain for the release of liability? And here, this is pretty simple stuff. The waiver has to be clear and unambiguous, because the law generally disfavors these types of waivers, and the courts construe the language strictly against the party who drafted it. So really here, you want to make sure you're using plain English, words people can understand. Don't bury the release in fine print of a larger contract. That's not a good idea. And be really specific about the COVID-19 risks and transmission. So let's talk a little bit more about how do we be specific. First, I would suggest have a separate COVID-19 waiver if you're considering one, rather than lumping COVID-19 into an already existing liability waiver with customers. That may not be considered clear enough to cover a COVID-19 transmission case under the courts. If you do want to put the COVID-19 language into your existing liability waiver, that might work too, but what I would suggest there is including very specific language on COVID, like we're going to talk about in a minute, that would be in a separate waiver. And make sure that you clearly spell out the amended language. So put it in bold, for example, bigger type, capital letters, something that jumps out to the person that this is new information that they're signing and agreeing to. And then have your customers sign it. Don't just put the language in the waiver and assume that their original signature holds, because it probably won't. In any waiver with COVID, you do want to make sure that you say COVID-19 is highly contagious. Customers have risks of contracting it. Again, that seems so obvious, but you really have to kind of spell things out in these waivers for people so they can't come back later and say, gosh, I didn't know that COVID was really contagious, because that's what they're going to say. You also want to say that, you know, you're following all the appropriate guidelines, local requirements, et cetera, that we've talked about. But you can say that even with complying with all those guidelines, and even with heightened cleaning, social distancing, masks, et cetera, businesses cannot fully eliminate the risk that a customer contracts COVID, whether from another employee or another customer, whether from droplets in the air, whether from touching something. When you put all that in a waiver and really kind of spell it out, here's the different ways that this virus can be transmitted. Spell out, here's the different symptoms of COVID. You may contract this illness and it may cause, fever, chills, all the different symptoms to look for. You would want to also identify how can COVID be transmitted asymptomatically, and note that this is a type of illness that folks can carry and transmit when they don't even know it. So you put that in a liability waiver to just further be specific. And then, as hard as this sometimes is to put in writing, identify the type of outcomes that occur if someone contracts COVID-19, that they can get very sick. They can be required to quarantine and have to miss work. They could transmit the virus to others, and in the worst case, be hospitalized or even pass away. Customers really need to agree clearly in language that everybody can understand, that they understand the heightened risk of contracting COVID when they're at your business, and that with that understanding, they agree that they will not hold your business liable for any damages resulting from the transmission that could have happened at your business, even if they allege or find that your business was negligent. And that's really key. We're getting towards the end for the question and answer, but I do want to just hit a couple more points before we do that, so you're kind of thinking about some other issues that are out there. I have been asked questions about what about minors and liability waivers. Couple key points here. Generally speaking, waivers that are actually signed by a minor, a person under the age of 18, are not enforceable. There may be some very limited circumstances, but generally minors lack the capacity to consent to contracts, so they're not going to be enforced. If parents or guardians are executing the waiver on behalf of the minor, you have a better chance of enforceability, but it is really unclear in the courts. Arizona courts haven't really come out and issued rulings on this either way, but the majority of states actually find that public policy precludes enforcing a parent's pre-injury waiver of his or her child's negligence or cause of action for injuries. There are some states that will uphold these waivers, and they particularly will do so in cases like non-commercial or non-profit, so school, municipalities, maybe community programs, things like that, because there is some recognition that these programs are really important for youth to engage in, and they might become unavailable if, nonprofits and other community groups or schools don't have protection from liability and could be bankrupted by lawsuits. So if you're running like a youth sports league or something like that, you may fall into one of those exceptions, but just know that Arizona courts have never issued a ruling on this, so it's kind of up in the air. So at the end of the day, whether or not you want to ask your customers to sign a COVID liability waiver is really a personal decision for your business. I would consider whether you're an essential versus non-essential business. If you are a non-essential business where the customer can walk away from your waiver, you're much more likely to have it enforced. And the pros to these waivers are a lot of businesses are finding that they are easy to put together, they're pretty inexpensive to put together, and they can potentially deter lawsuits on the front end. They can, definitely limit liability for a business if you get sued and the court enforces your waiver, but they may even stop a plaintiff from suing you in the first instance because they think that the court's going to enforce it, so they won't sue you. Or if they do sue you, you can use the liability waiver to help leverage for an earlier and maybe even a cheaper settlement with the plaintiff, because you've got something in your back pocket that puts that plaintiff at risk of not being able to recover the damages they want, because if the court enforces the waiver, they won't recover. The downsides of waivers, some folks worry they might alienate customers. That is certainly a consideration for your business, and one that you will know, better than an outside person like me. And I've heard bantied about a little bit that some folks think waivers could actually give plaintiffs the idea to sue a business if they become infected with COVID, because they think, aha, that business made me sign a waiver. They must know something was wrong. That's speculation. I don't know if that's true or not, but it's certainly something to think about as you kind of weigh the pros and cons. What I can tell you is that I represent a lot of different businesses from small to Fortune 500. And COVID liability waivers are becoming increasingly used at all levels of the economy right now. So they are definitely something gaining in popularity. And if you decide to use one for your business, you will not be alone by any stretch. But I do want to tell you as well, just remember, it's not a get out of jail free card. It is still abundantly important to comply with all of the applicable orders, requirements, and recommendations for safety that helps lower the risk of COVID transmission in your business and your industry. Certainly you want to do that to protect people, but failure to comply can get your business in trouble with fines or, getting shut down by regulators. And if a court also determines later that your business didn't comply with requirements or guidelines, they could find your business was potentially grossly negligent or even reckless. And the best COVID liability waiver won't get you out of that. So just remember, a waiver, you still have to try to take all the best steps we talked about earlier. And lastly, before we get to questions, I am certainly not an insurance agent or broker, but insurance comes up a lot for my clients. So I just wanted to put out a couple thoughts for everyone to keep in mind. Many people ask me, will insurance cover losses or costs if I get sued for one of these COVID transmission claims? And the answer is you have to check your policy language because that's what's going to control. What I can tell you from clients I've seen is many business and general commercial liability policies exclude personal injury or losses due to things like communicable diseases. So they may not be covered, but it's always the best practice to just look at your policy, talk to your broker, talk to your agent, and get all the information you can about any policy that could potentially apply. And I did want to let folks know, be careful as you're renewing insurance policies now. I've had a number of clients actually tell me that insurers are sometimes trying to kind of slide in exclusions that didn't used to be there because COVID is going to be with us for a while. So we're seeing insurers add things like communicable disease exclusions when they did not exist before. We've also seen some policies broaden the definition of the workplace. Now that folks are working at home more often, and that trend is expected to continue, many policies are actually defining that workplace can include the home or home office. And that just opens up the possibility of additional potential employee injuries. So just things to kind of keep in mind as you're renewing your policies. Just really carefully read through everything, ask your broker or agent all the questions you have, and just make sure you know what you're paying for so that you're not surprised later on. And with that, I have talked for a while, so I wanted to go ahead and see if there are any questions today. I'm going to go ahead and stop sharing my screen so you can actually see my face if you have questions.
Wow, my brain is on overload. That was a whole lot of information, really good information. Thank you so much, Andrea. Any questions from our group? And I'll take one or two questions. I know somebody just texted me a question. They had to get off, but their question was, they have an employee who keeps using the excuse that they have been exposed to somebody who has tested positive for COVID. How do I keep this person coming to work and being able for work?
Oh, that's a tough one. Well, couple things. If the person truly has been exposed to COVID through someone else, they probably shouldn't be coming to work. They should be home in a quarantine situation. And if at all possible, working remotely. I understand that's not possible for every business, but to the extent possible, have that person work remotely. I'm suspecting through the question that you may not believe that the person really has been exposed and is kind of using that as an excuse. If you feel that is the case, that's a little tricky one because you have to be careful not to push too far with the employee, because then you can kind of get into some of those employment related claims where they try to say, well, you're digging into my private information about a disability of myself or a family member. That is a tricky one. You know what I would suggest actually, and I'd be happy to do this. I have a number of fantastic employment lawyers in my office, and I would be happy, Terry, if you would mind, I could get back to this person directly with just some free thoughts from the folks in my office who practice in that area day in and day out, and give you maybe a more real specific response. And I'd be happy just to send that right over.
We may actually work with them to bring them on for another topic, because I think that as we continue to roll forward, Paula's shaking her head because as a small business counselor, I bet she's getting that question too. That might be a great topic. One more question, because then I want to jump to Paula, because I want to make sure Paula gets in her updates that are happening. In a small business, it's hard to keep anonymous who is tested positive. And I've also heard this one as well.
Yeah, that is very true. And I would say you just need to do the best you can. I mean, you obviously want to avoid using that person's name. And even when you're contact tracing, if you know a person has been tested positive and you need to then talk to the folks that person worked with, people are going to figure it out. And there's only so much you can do. So really what I would say is you just have to do your best to keep it anonymous. If someone directly asks you, is it Bob, for example, you would say, I cannot answer that question, but you just have to do the best you can to contact trace and, look at anyone who's been around that person and just try to be anonymous. It's so tough,
Great. Well, I know that we have one more. What if if a person who is likely has COVID but has come back to work and refuses the suggestion they get tested?
Yeah. You cannot, as I understand it, you can't force them to get tested. However, there are public health guidelines right now. If you look at what the EEOC, the Equal Opportunity Employment Commission, has set forth, there are guidelines that you can at least force them to stay out until that person's symptoms are gone for at least 72 hours. And if that person refuses to get tested past that but has no symptoms, there may not be much else you can do. But again, that's something we're going to have the employment lawyers weigh in on as the regulations come out on this, which literally they're changing every day.
Okay. All right. Well, I know that we've got a lot of questions. Keep those questions coming, because Fennemore Craig has been a great partner in helping get us this information out. So I want to switch to Paula. Paula, I know that your time's been cut short, but boy, that was really valuable information. And I think it's going to help you too, as you continue to counsel businesses. So, Paula, what's changed?
All right. So, okay, look, the slides are coming up, I think. Otherwise, I can share. Yes, that was great information. So I learned a lot. So let's talk about some quick updates to the PPP and the EIDL program. Let me go ahead. I can certainly share my screen here just to bring them up quickly, if that helps.
Perfect. There you go.
Okay, do you see them? Okay.
Yes, we do.
All right, here we go. Okay, so just very, very quickly, a couple of changes here on the EIDL loan program, the Economic Injury Disaster Loan. That advance grant that was the amount up to $10,000 is no longer available. So the EIDL loan program itself remains open and can be accessed at the SBA.gov website. And but the disaster grant up to $10,000 is not. So just to quickly refresh your memory, if you've not applied for the EIDL loan, these are just some basic terms and conditions. This is the one, it's up to $2 million, but they're capping it about $150,000. It's the 3.75% up to 30-year terms, 1-year deferment on the first payment, and no prepayment penalties. So if you've not applied for that loan and you're feeling a need for funding, you can still access and apply for that loan. We are beginning to get some clients saying that they've been declined. There is a reconsideration process, and so if you've received a decline email, I would encourage you to go back to that contact information, develop a nice succinct explanation as to how you've been impacted by COVID, and what you need the funding for, why you need that funding, and reach back out to them and ask for reconsideration. So you can do that. PPP loan, recently the date for application has been extended to August 8th. There are still funds available, and you will apply through your lender. So here again for the PPP loan, you apply through a lender, but to find out who those approved Arizona lenders are that are still offering the PPP loan program, not all are. You can go to the SBA.gov website and you can find lists of lenders. Terry, I believe they can contact the Chandler Chamber as well.
Yes.
You know of maybe some local lenders that can still help them with that.
Okay. That is true.
All right. Just PPP loan forgiveness. We're getting a lot of questions about, I've used the money. I'm ready to go through the forgiveness process. So our understanding of the SBDC is that even the SBA, they're kind of getting their process in place for processing these forgiveness applications from the lender. So what we're just recommending to our clients is that once you've used those monies, contact your lender, stay in touch with them, let them know you're ready for forgiveness, find out what their process will be. There will be an application that needs to be filled out. And you can, some of the lenders are putting these online, but here again, I think it's going to be different for these different lenders. But I would encourage you to go to the U.S. Department of Treasury, and I've got the website listed, and you can pull down the applications. There is an easy form application, which I encourage you to start with first. On the first page of that application, there are kind of 3 big areas that you review. If you can check the box in any of those 3 areas, that's a good thing because you can use the easy application form. If not, there's a more comprehensive form that you would be filled out, that you would need to fill out. So I would encourage you, go to the Treasury site, download those applications, take a look at them, get familiar with them as an initial start as you're waiting for your lender to be ready to accept your forgiveness application. And also SBDC, we're helping our clients with questions about the forgiveness process and those applications. So I'll be talking about our services. We're a resource that you can certainly reach out to, and we'd be happy to help you with any of those questions. Now we are starting to get more questions about, I've used up the funding that I've received from disaster programs. Are there any grants available? There are a few out there, and I've just listed a couple. Terry, you may know of more. There is one through Maricopa County that is available. Now, I believe this one is one if you've not received any of the disaster loan funds. But there is a Maricopa County grant. I did find this one through Chandler, the Choose Chandler grant to reimburse for PPE equipment. But Terry, I don't know if you know of any others, or maybe others in the East Valley may know of additional grant programs, but reach out to your cities, reach out to your chambers, and just see what might be offered currently or perhaps in the future. So stay in touch on those programs as well.
I do know that the city of Chandler, on their grant program with economic development through the Chandler Industrial Development Authority, the PPE equipment grant, it's a 1-page. You have to submit your receipts, and you can get up to $500 right away as long as you're a Chandler-based brick and mortar business. And you just show receipts for masks, sanitizers, gloves, and it's a pretty easy, quick application, and they're really turning those around quickly.
And that's great. Listen, every bit helps, right? Reducing those expenses. And just very quickly, for those not familiar with the Small Business Development Center, we're a national network. The Maricopa SBDC is part of the Arizona SBDC network, and really what we offer is no-fee counseling. No catch to that. We're funded by the SBA at the federal level and here locally by Maricopa Community Colleges. So we have presence across Maricopa County. However, we are currently all, holding meetings virtually, and we're helping with disaster loan program assistance. So if you have questions, please reach out to us. Funding sources, many of our clients are now looking for additional funding sources. Definitely something we can help you with. Also helping you look to see, your lender readiness assessment, right? What are your strengths? What are some opportunities? in preparation for a first meeting with a lender. So you put your best foot forward. We can help you get ready for those lender meetings. We're starting to help clients with some resiliency assessment, really looking at, we're making it through, we're struggling through, but now taking a look at the business big picture and identifying what do you need to do now moving forward to increase your resiliency for the future, for now and in the future. Some of our clients are looking to expand to customer segments. So we have experts in export and international trade, and perhaps you have services and products that may be a good fit for some government contracting. So the PTAC group also offers no-fee counseling, all things government contracting. So I've put our website there for you to refer to, and that is where you go to request our services. So please just go to our main page, click the request counseling, fill out this very simple form that's going to put you into the queue, and you will be assigned a lead counselor, and we'll sit down and have an initial conversation with you to identify how we can support you with your business. And it is no fee counseling, so zero budget line item. So I would encourage you to check us out and take advantage of the expertise that we have to offer to you.
Oh, I just cannot thank you and your team enough, because you have been there pre-COVID, post-COVID, during COVID, and your team has been amazing and has been a tremendous resource for our businesses.
Thank
You
you.
have not taken advantage of these opportunities. She says no fee, it's free. So please make sure that you do that. I know that our time we went over today, and I want to be respectful of everybody, but please, please, if you have questions on how to navigate this with your business, we are here to help. And Andrea, I want to thank you and your teammates at Fennemore Craig and your continued support. You are so knowledgeable. I took 4 pages of notes. Just because it was really good. So, and we will get the PowerPoint out to all of those that are registered for attendance. We'll get that out to you, as well as Paula's information. So thank you both for joining us today. Keep those questions coming. Next week, we will have the U.S. Chamber on with us, and they will be talking about some of the new programs that in funding that we are working with them on. And then the following week, we will have DES on board. Anybody who's on unemployment, those extra benefits are running out as of the end of this month. And so we are going to help businesses navigate that. How do you get your employees back into your place to work? So thank you for joining us, and we'll see you next Thursday at 10 a.m.
Thank you.